Hey guys, I'm doing this video as a reminder of many of the things that I've said in the past about why Donald Trump did nothing wrong with the boxes of documents he had at Mar-a-Lago. I figured a lot of people are going to be depressed after Trump had to plead not guilty to what is a total political prosecution. And I'd like to remind everybody of some of the facts that should shut this trial down pretty quickly if Trump gets a real judge and not some political hack that was shopped out by the Democratic Party. So let's get into it. Hey guys, welcome back. So everybody by now knows that Trump was arraigned on Tuesday on 37 bogus indictments about the classified documents. I can say with confidence that they're bogus indictments because Trump was president of the United States, and because of that, he did nothing wrong according to at least two court cases, one a Supreme Court ruling and one a precedent case from 2012. On top of that, there's the Presidential Records Act. So let's get started. In 1988, there was a Supreme Court case called Department of the Navy versus Egan. And in that case, the court ruled that a president has the ultimate authority to classify and declassify anything. In the opinion, it said, quote, "The president, after all, is the commander-in-chief of the Army and Navy of the United States. His authority to classify and control access to information bearing on national security and to determine whether an individual is sufficiently trustworthy to occupy a position in the executive branch that will give that person access to such information flows primarily from this constitutional investment of power in the president and exists quite apart from any explicit congressional grant." Now, that means that the Constitution gives the president the authority over classified and declassified materials and that the Congress has no say in it. Now, there was another case that was ruled in 2012 by an Obama appointee Judge Amy Berman Jackson. And that case was Judicial Watch versus National Archives and Records Administration. Now, this case was based on President Bill Clinton having audio tapes that he took home with him and kept in a sock drawer. Those tapes were from the Oval Office, and Judicial Watch thought that the American people had a right to know what was on them. Now, Judge Jackson ruled, and I think correctly, saying, quote, "The court will grant the motion to dismiss pursuant to Rule 12 because plaintiff's claim is not redressable." Now, here's the important part. The judge wrote, quote, "NARA does not have the authority to designate materials as presidential records. NARA does not have the tapes in question, and NARA lacks any right, duty, or means to seize control of them. In other words, there has been no showing that a remedy would be available to redress plaintiff's alleged injury, even if the court agreed with plaintiff's characterization of the materials. Since plaintiff is completely unable to identify anything the court ordered the agency to do, that the agency has any power, much less a mandatory duty to do, the case must be dismissed." Folks, do you understand that no one has ever appealed this case, which means that it is a precedent? And if it is a precedent, then the Trump lawyers should be able to walk in on day one of the trial, point to this case, and ask the judge if they could end the trial before lunch. So we have the first case I spoke about, Department of the Navy versus Egan, where the Supreme Court ruled that the President of the United States has the ultimate authority to classify and declassify anything at will. And we have the second case, which was Judicial Watch versus National Archives and Records Administration. That is a precedent case where Judge Amy Berman Jackson ruled that NARA has no authority whatsoever over the president on what a president deems as presidential record. And so if that is the case, then how come the Biden administration, the Biden DOJ and the Biden FBI were involved in making a case out of records that the president of the United States took and declassified? And for the liberals out there who are watching this, you can't say that these records were classified because the president of the United States took them and he had the authority to take them and he had the ultimate authority to have classified documents and to declassify documents. What this means is that even if Trump did not declassify the documents, it doesn't matter because he was president when he took them and they were automatically declassified. And Trump also last week revealed a presidential memorandum that he wrote on January 19, 2021, the day before he left office, which means that he was still president. And written on that presidential memorandum was the fact that he declassified all the Crossfire Hurricane documents. which were the documents that the jackbooted thugs of Chris Wray's FBI stormed Mar-a-Lago for. That was the evidence against the FBI and DOJ for Crossfire Hurricane. All of this is nothing but election interference, and that's what it's been all along. Hopefully, Trump gets a real judge who understands the law and understands the constitutional rights of a president, even a former president in this case, against a totalitarian regime that wants to take him out before an election. All right, that's it. Thank you for watching this video. We'll see you in the next one.